All right, good morning. Welcome back. Welcome back. Any questions before we get started? No? Okay. Let's start with the quiz. Okay. Okay. Oops. Wrong one. Okay, here we go. All right. So a straightforward question. In Wickard versus Filburn, the Supreme Court upheld the regulations under the Agricultural Adjustment Act solely on the basis of the Commerce Clause. All right. Another 10 to 15 seconds. True or false? You gotta be here on time. No, you're not here. If you're not in the room of the class, you're not here on time. That doesn't count if you're in the bathroom. All right. I'm going to stop it here. See what the results are. Okay. That's the right answer. Okay. The answer here is false. And let me explain to you why. Oh, I can't let this fall run. Okay. The answer to this question is false, and I'll tell you why. The key question in this one, so the key word in this question is solely. Right? Only. In virtually every case we have concerning the separation of powers, the court will always rely on the necessary and proper clause. They may not always say it, but the necessary and proper clause is always lurking in the background. All right? So in any exam question I can pose to you, if I ask, does Congress have the power to do X, whatever X is, your answer should always talk about the necessary and proper clause. Don't only give me Commerce Clause. Okay? All right, so the answer to that one is false. So about 75% of you got that right. Okay. Any questions on that? Yes, sir. Folks. Any case involving enumerated powers, which is all we've done so far, right? We'll do cases that don't involve enumerated powers, right? But in any case where we're asking, does Congress have the power to do X, your answer should work in the necessary and proper clause. Make sense? Okay. All right. Our topic today starts off with a bit of a detour. Then we go back to what we've been talking about. The first case we have today concerns what's called the spending power. That is the power of Congress to spend money. Now, you may think, Josh, what does this have to do with, regulation of commerce and the like? Well, this is a case involving enumerated powers. The question is, does Congress have the power to spend money in this fashion? And what clause of the Constitution we're relying on here? As always, it's necessary and proper clause. So virtually every case in this unit so far is about the necessary and proper clause, whether or not the court actually discusses it. So first we'll talk about the spending clause with South Dakota versus Dole. And then we'll move on to the enumerated powers doctrine, more modern cases, with Lopez, Morrison, and Raich. Okay, makes sense? All right. Where did I finish off last time? Who was last? Okay, so Katie, I called on you?
Yeah, I was down there.
Don't move around.
Well, that's not my fault. Sorry.
It's not your fault.
Well, someone was sitting in my seat, so
Oh, that's a shame. Okay, well, I apologize. It was not your fault. Okay. I'll start here. Okay, yeah. Okay. Does the Constitution have a clause that gives Congress the power to spend money?
No, it does not.
Okay.
May I take out my constitution?
You can always take out your Constitution. It's always permissible. So, yeah. I will never say no to that question. And if you don't have yours here, you should, but I have it on the screen as well. So let me ask you a question. Can Congress collect taxes?
Yes.
They can raise money.
Yes.
Okay. And what can they do with that money?
They can use it to implement the.
And what do we call using money usually in general,
spend.
Okay. So here we have an obvious question, right? We know the Constitution allows the government to raise money, right? We can raise money. They have money. They got to do something with it. And usually when you have money, what do you do with it? You spend it. But there's no express provision that says you can spend money. But from the earliest days of our government, our Congress started to spend money. So what provision of the Constitution actually gives Congress the power to spend money? The answer is a necessary and proper clause. I feel like a broken record, keep coming back to this point. But a spending bill is a law. It says we need to spend money on horses so to have a postal network, right? We need to spend money on wagons to have an effective postal system, right? It's actually the necessary and proper clause that gives Congress the authority to spend money on whatever they're spending. But we have a debate, though, right? What can Congress spend money on? And in the early years of our republic, this debate was very well documented. On one side of the debate, we had Alexander Hamilton, right? He of Broadway fame, right? Hamilton was the Secretary of the Treasury under Washington. And we already studied Hamilton when we did McCulloch v. Maryland, right? Which one am I going? Did I already do this for you last time? Okay. Leslie? Okay, I'll call on you. Leslie, let me ask you this question. Let's do a little review. What was Hamilton's position with respect to the Bank of the United States? What did Hamilton think about whether Congress could charter a national bank? Do you remember? I'll come back to you. Sergio?
He had like a broad view, so he agreed that with Washington that we should have a national bank.
Okay.
He basically he was all about the bank. He wanted a national bank because to him a strong central government with a strong national bank would be able to help prosper this fledgling new democracy.
Okay, good. Hamilton had a very broad reading of the necessary and proper clause with respect to the bank. He thought that if it was useful for Congress to charter a bank to regulate commerce, then Congress could do it. Right? He had a very broad reading. Madison took the opposite position. Leslie, do you remember what Madison's position was on the bank? Well, he was against it, but how did Madison as well as Jefferson read Congress's necessary and proper clause powers? Yes. Madison and Jefferson had a very narrow reading. They said we should only allow Congress to do what's specifically enumerated. We shouldn't allow them to go too far outside. Necessary means necessary, strictly necessary, right? We know, though, in the debate between Hamilton and Madison, who prevailed? Hamilton. We have a similar situation here, right? Hamilton takes a very broad reading of the spending power, right? Hamilton said that Congress can spend money on whatever it wants. And what's the limit? They can provide for the common defense and general welfare of the nation. So Hamilton takes the language right from Article 1, Section 8, which is called the spending clause. Doesn't actually say you can spend money, but he goes right to this provision and he says, look, it says right there, they can collect taxes and then use that taxes to provide for the common defense. That means spend money, right? So anything that promotes the general welfare could be incorporated. Now, what does that mean? It's broad, right? Anything that promotes our welfare, how we're doing, right? Defense, that can be just about anything. Madison, once again, took the narrow view. He said that the limit, right? The limit comes from the necessary and proper clause, which he read as narrow. He said that Congress can only spend money in order to execute its other powers. Again, go to the necessary and proper clause. Congress shall have the power to make all laws, which be necessary and proper, to carry into execution the foregoing powers. That is Article 1, Section 8. Madison said you can only spend money to execute the stuff in Article 1, Section 8. Not this broad notion of general welfare, but to go forward. So you could pass a bill to spend money to buy horses, so you have a postal system, right? You can pass a bill to spend money to buy wagons for your postal system. If Congress opens up new courts, they can spend money to buy the bricks needed to build the new court, whatever it happens to be. But the spending has to be done pursuant to what Congress can do. Hamilton says, no. We can give money to the states, right? We can give money to the states and encourage states to do stuff. Well, we had this debate, and who won? Who prevailed? Once again, Alexander Hamilton prevailed. He won almost all these debates. Madison gets a lot of the credit, but Hamilton actually had the arguments that prevailed in the long run. But the courts still are sympathetic to Madison, right? And the courts have put certain limits on the spending power. Right? Now, when Congress spends money on its own, no one really cares, right? When Congress wants to buy this or buy that, that's their role. But Kobe, when Congress wants to give money to the states, right? What's the risk when Congress is giving money to the states? Why is that potentially problematic? I heard Leslie whispering, but yeah. So let's say, Kobe, you say, Professor Blackman, I want to take you out to lunch. What's my reaction going to be? Josh, I want to take you out to lunch. How am I probably going to react? No. No, you're too nice. My reaction is, what does he want? I mean, I will not let a student pay for my lunch at all under any circumstance. I'll pay for theirs if they want, but you're not giving me anything for free. I've had students who try and give me gifts during the semester. I'm like, no, wait till after the semester. It just creates conflicts of interest. I don't want free stuff from you. No, it's a serious problem. I mean, if you know that a student's giving me gifts, it might try to curry my influence, right? There's no free lunch, right? Whenever someone gives you a gift, there are strings attached. I promise you. You're laughing. It's true. There's no free lunch. If someone's giving you something for free, there are going to be some strings attached to them. They want you to do something, and it's a lot cheaper to buy your lunch than just to pay you to do it in the first place, right? It's human nature, right? If you have a truck, people want to help you move, whatever it is, right? There's no free lunch. When Congress is spending money and giving money to the states, they'll often attach what are called conditions, right? We'll give you this money, but you have to do something, right? We'll give you this money, but you have to do something, right? You have to maybe spend the money in a certain way. Maybe you have to meet certain standards, right? So let's say the federal government gives the states money for education. The students have to maybe teach certain topics, right? Maybe the students have to take a certain exam, right? Let's say the government gives money for health care. Okay, then the states have to provide a certain level of care for their patients, right? There are always strings attached to it. But the courts are concerned that maybe if the strings are too severe, right, the strings are too stringent, then there's really no choice, right? That the states don't have the free will to say no. Now, of course, states can always say no. But the financial consequences are so severe that maybe the state really has no power to say no. And that's the issue that arises in our first case, South Dakota versus Dole. All right, any questions so far? Jason, you want to give me the facts in Dole, please?
Yeah. So I guess at the time, South Dakota, the state has a minimum age that 19-year-old can buy alcohol.
Okay.
It's less than 3.2 alcohol percent.
By the way, you guys know about this light beer stuff? You ever know about this? Some states have, Oklahoma has it, some states have it. We'll do another case with light beer. There is so much litigation over alcohol, it's insane, right? It comes up over and over again, but you see this light beer. All right, Jason, go on.
So the federal government, Congress basically want the state to raise their minimum age to 21.
Okay, now, Jason, let me pause you right there. Could Congress pass a law directing the state to raise their drinking age?
No.
Why not?
Because it's not among several states, each state local
Well,
entity.
in other words, why can't Congress issue a command to a state to raise their drinking age?
That's part of the state police power,
Yes, and if it's part of the state police power, who does not have that power?
federal government.
Bingo. Okay, Congress lacks that power, right? Congress lacks the power to issue a directive, a command, to the states to modify their drinking age. Okay, they cannot issue that command. We'll study this in about a week, but this is called the anti-commandeering principle. The anti-commandeering principle. We'll say this later, but it generally means that Congress cannot issue a command. And the reason why is actually based on the necessary and proper clause, right? The courts later said that it's not a proper exercise of federal power to issue such a command. It might be necessary, might be convenient, but it's not proper. We'll get there later, but I'll just give you a little preview. Okay, but Jason's exactly right. Congress cannot directly order the state to increase their drinking age. So Deanna, what does Congress try to do here instead of commanding the state? They sort of like take a side route, right? How did they get there?
They passed a bill that would withhold 5% of their, I think it's their transportation expenses that Congress gives them if they didn't, they would withhold that 5% if they didn't raise their drinking age.
Okay, very good, very good. Congress gives money to states for highway funding, right? To build highways, to improve highways, to pave over the put new asphalt, whatever, cement. I don't know what you use, but whatever it is, they give money for them to make better and new roads. Congress says, okay. We hope you like this money. I hope you're enjoying it. If you want to keep receiving it, you got to play our game. And what is that game? You have to raise our drinking age to 21. And if you don't, no big deal. We'll just withhold a couple percentages of the money we're giving you. Right? We're not punishing you. We're simply withholding money that you would otherwise get. Now, if you raise your drinking age, keep your money. Everyone just get the deal, all right? If you want to keep the money, you have to raise your drinking age. Now, the state argued, no, you can't do this, right? The state argued, you can't make us raise it directly. Therefore, you can't do it indirectly. Everyone see that, right? That you can't make us raise it. So therefore, you should not be able to dangle the strings to try to induce us or encourage us to do so. Everyone with me? All right, Vanessa, what did the majority, Chief Justice Rehnquist, I don't think, was he Chief Justice? Yes, he was Chief Justice here. That's right, it was 86. What did Chief Justice Rehnquist hold here?
That the spending provision is fine, essentially, because of the four
Okay, let's walk through them, right? The court puts together this like 4-factor test, and it's actually 5. They say 4, but there's actually a 5th factor. But let's just start with 4, right, Vanessa? The court puts together these 4 factors. They look, there are limits in the spending power. It's not unlimited. But there are these 4 general restrictions. Okay, walk me through them, Vanessa.
So the expenditure must be for the general welfare.
Okay, where does that come from?
Article 1, Section 8.
That's Hamilton, right? Right there. The spending clause. It's not called. We call it the spending clause, but that's what people call it. Article 1, Section 8 says that the spending must be for the general welfare, right? Vanessa, is there anything that's not in the general welfare?
I don't think so.
Yeah, everything's in the general welfare. So this factor is like check, right? You know these 4-factor balancing tests, like 3 of them always check, right? The first one's always checked. In fact, the court says we have to defer to the judgment of Congress. What that means is if Congress thinks a law is in the general welfare, the courts will not disagree. So it's an automatic, right? This one's checked automatically. All right, is that Caitlin? Caitlin, what's the second factor? That this actually comes up a lot in litigation. It's important.
If the states want the money, receipt of the federal funds, it must do so unambiguously, enabling the states to exercise their choice knowingly, cognizant.
What does it mean for the condition to be unambiguous, just in your own words? What does that mean? What does it mean to be something? What does unambiguous mean in general? What does ambiguous mean? Do you know what ambiguous is? Okay. You read your notes correctly, but you gotta look up words you don't know. Katie?
Clear, to the point, so that people can understand it just plainly.
Why is it problematic, Katie, if a condition is not clear, if a condition is ambiguous? Why is it problematic for a state?
I guess they wouldn't know what they were agreeing to.
Yes, right? You know this from contracts. If a contract is ambiguous, if it's not clear, and you don't know what you're getting into, it's not enforceable, right? You can't have hidden contract terms. You can't have terms say, well, if you fail to deliver the widgets, we'll withhold some money, right? We won't tell you how much money. We'll withhold some money. That would not be an enforceable contract in any regard. You need to know what you're getting yourself into when you sign it. The same rule applies to the federal government. If the federal government says, we will give you money on the condition you do X, it has to be clear what that condition is. And it has to be clear how much you stand to lose, right? You can't be guessing, well, do we lose $1 million or $1 billion? I don't know, right? You have to have a clear statement, an unambiguous statement in the statute about what the condition is and how much money is at risk. This second factor is actually litigated quite a lot, because sometimes you can imagine Congress is sloppy, and they're not always clear with what they do. So this factor does get litigated. So number 1 is like automatic. Number 2 does get litigated. But in this case, it's not a big deal, because the statute says if you don't, was it 5%? If you don't make your drinking age 21, we take 5% of your highway funds. So there's no ambiguity here. Jamie, what's the third factor?
That the condition must relate to the federal interest for which the spending program was established.
Okay, what the hell does that mean? That one gets students in trouble.
Like that it needs to connect with each other, the reason why.
Okay, good. I like the word you use, connect, okay? Connect. There has to be some sort of fit or a connection between what Congress is spending money on and what they're trying to achieve. So Jamie, just walk through this with me, please. What's the connection here between highway funds and drinking age?
I think they were saying that, like, the safety of the traveling.
Okay, very good. The majority suggests that there is a connection between highways and drinking ages, right? That if you have more underage drinkers, they may get behind the wheel, and they may contribute to accidents in the highways. Or, let's say you have South Dakota with a drinking age of 18 and North Dakota with a drinking age of 21. You'll have all the teenagers from North Dakota driving to South Dakota to get liquor, right? So therefore, the majority says there's a connection, right? A relationship between highway safety and the drinking age. Yes, sir.
If one is the general welfare, wouldn't there almost always kind of be a federal interest in relation to?
Yes, that was my next question. There's always going to be a relationship. But the question is, how close is that relationship, right? How close is the fit between what they're trying to achieve and what they actually achieve? And this is the disagreement between the majority and the dissent from Justice Sandra Day O'Connor, right? I'm going to jump into O'Connor. I'll come back to the fourth and fifth factor in a minute. But Justice O'Connor sees the case very differently. Nancy, why does O'Connor dissent on this? And she dissents on point number 3. She doesn't really dispute 1 and 2. She's fine with those. But her disagreement's on number 3.
I remember she says that she thinks the relationship is out of scope.
Yeah, what do you mean? Give me a little bit more, please. You're exactly right. Nancy, let me ask you this question. Does Justice O'Connor think that there's a close fit between highway construction funds and the drinking age?
No,
Okay, why not?
because the drinking age deters, but it doesn't have to do with like what you're saying, like construction.
Yes. Okay. And this is the big point that O'Connor makes. Very well said, Nancy. This is the point that O'Connor makes. The money is being spent on asphalt, right? Gravel, right? Paint. I don't know. Whatever you need money on to build a highway. What do I know, right? The money's being spent on highway construction stuff, gravel and asphalt. It's not being spent on reducing teenage drinking and driving, right? O'Connor would require the money to be spent on the thing you're conditioning, right? If the condition is about drinking age, the money should be spent on drinking age. Maybe, there's money being given to raise awareness for underage drinking, right? Or rehab programs for teenagers. I don't know, right? I'm making stuff up, right? There has to be some sort of connection, some sort of fit between what Congress is spending the money on and what the condition they want. And she uses this word, which is sort of a strange word. I hope somebody looked it up. Germane. Germaneness, right? Germane is just a word for relationship, right? It's a synonym, right? That there has to be a close fit or a connection, right? In order to actually spend this money, you have to show that the money is being spent on the condition. You're spending money on teenage drinking and driving. In contrast, highway construction is completely different, right? Lots of people build highways, right? Lots of people drive on the roads. It's not just teenagers drinking and driving. O'Connor would demand a closer fit between what Congress is spending money on and the condition. But the majority only requires a relationship, right? O'Connor says it has to be germane, connected. See the difference? The majority says as long as it's in the ballpark, right? Drinking and driving, teenagers, highways, yeah, it's all the same thing, right? Whatever, it's close enough. But for O'Connor, it's not close enough. She demands more. She demands that Congress can only spend money on the thing they're regulating. They cannot spend money on these related topics. Okay? Let me say this another way, right? For O'Connor, Congress can use its spending power to put requirements on how the money is being spent, right? If I'm giving you money to construct a highway, I can tell you, here's the width of the highway, right? Here's how thick the asphalt has to be. You have to use this kind of paint, right? You can put conditions on how that money is being spent. But you can't use it as a backdoor regulation, right? You can't use it as a means to change the drinking age because you can't do that directly. The money can only be used with conditions of how that money is spent. In other words, she writes, Congress doesn't have the power to go beyond specifying how the money should be spent. Again, Congress cannot go beyond specifying how the money should be spent. They can't regulate other means. Okay, so I want to get the O'Connor point. O'Connor was in dissent, as I'm sure you know by now. She was the only one. And the court really hasn't picked up this third element in the O'Connor direction. So the majority is still good law on number 3. But I think O'Connor makes a very different, almost Madisonian reading of the spending power. But once again, Hamilton wins. Must be nice to have Hamilton on your side. He prevailed here. Okay. So any questions on the third factor? The fourth factor doesn't really come up much, but it asks if there's some other provision of the Constitution provides an independent bar. What the hell does that mean? Do I have it up here? I don't even have it up here. The 21st Amendment, right? We studied it the first day of class. The 21st Amendment repeals prohibition. But it does more than that. The 21st Amendment also gives the states the power to regulate alcohol. Right? This is why we have dry counties and dry, we don't have a dry state anymore, but we have dry counties. The reason why counties can be dry is because the 21st Amendment authorizes it. Right? It says, Section 2 of the 21st Amendment. The transportation or importation into any state for the use of alcohol in violation of the laws thereof is hereby prohibited. That phrase, in violation of the laws thereof, means states can still regulate alcohol. So the question was, did this spending law run afoul of the 21st Amendment? A couple of justices said it did, but the majority rejected it. Don't worry too much about the 21st Amendment. Okay. It comes up all the time. There's so much litigation over alcohol. It's insane. It's one of the most regulated items in the country. Okay. That's factors 1 through 4. But then the court, Chief Justice Rehnquist, identifies a 5th factor. This one's important, right? What's this 5th factor that the court recognizes?
Well, they don't want the Congress to put a condition on any money that would be coercive.
Okay, tell me, what does coercive mean?
They kind of unfairly force them into
Right, but come on, Ben. You can always say no to money, right? No one's putting a gun to your head. Can't you say no to money?
Well, say if they were going to cut off 100% of federal funding, then that would be...
Oh, so, is there some sort of God-given right to have federal funding that can never be taken away?
Not God-given.
But then what? Congress can give money, they can take it, right? I mean, if you're giving your son an allowance and then you decide, you know what, you're a bad boy, I'm not giving you any allowance anymore. Why can't Congress do the same? If a state's misbehaving, take the money away. What principle of law says that the Congress can't withdraw money they decide to give in the past?
I don't know.
The court doesn't really sketch this out. As a matter of philosophy, it sounds right. It's really mean to withdraw money that people are relying on. But here, it's not about whether it's mean. It's about whether there's coercion. That is, if someone offers you so much money, you can't realistically say no. Why? Because if the state says no to that money, they'll need to tax their own people for it. In other words, their people are already paying federal taxes, but they won't be getting back their share. So they'd be double taxed to actually fund whatever they're doing. And the idea is the money, this offer, it seems like you're having free will, but there's actually compulsion. Think of the duress concept when you did contracts, right? That there are some contracts where you're not actually engaging in an act of free will, that you're under some sort of force or pressure. And he said such coercion would be improper. One second. We'll get to this next week when we do the Obamacare case, NFAB versus Sebelius. But Chief Justice Roberts invoked a somewhat memorable phrase, which I think helps to explain it. There's an old comedy sketch where a burglar walks up to a guy and he puts a gun to his head. He says, "Your money or your life? Your money or your life?" And the guy's just sort of standing there. He's like, "What are you doing?" He's like, "I'm thinking about it." I mean, which choice are you going to take? You're going to take a bullet to the head, or you're going to give the money, give your wallet. So Roberts basically said there are some deals that are so tough that you really don't have a choice. The court didn't find that the South Dakota law crossed that line. They're only withholding 5%. But in the Obamacare case we'll study next week, the court found that a state could lose 10% of its budget, billions of dollars, would bankrupt the states. Right? If they didn't join the Obamacare Medicaid expansion, they'd lose all this money. That was a bridge too far. The Obamacare case crossed the line identified in South Dakota v. Dole. Right? Dole drew the line, and Obamacare crossed it. So for nearly 20-something years after Dole, no line was crossed. When I went to law school, will any law ever cross that line? Okay, now you got it. Yes?
So my question is, would it be fair to say that it's almost based off of McCulloch v. Maryland in the sense that it's saying that if the state of South Dakota, let's say if it was like 15-20%, which could bankrupt the state, would basically destroy the state as an institution? Like on the flip side of the...
Yeah, no, I see what you're saying. It's not exactly, because Congress could just, his question was, if you remember McCulloch v. Maryland, could the state destroy a federal institution? And he's asking that on the flip side, could the federal government destroy the state? I don't think it's exactly the same idea, because the Supremacy Clause doesn't run that way. But the general idea is if a state lacks a meaningful choice, the court says, then it's compulsion. But I see your question. Okay. So the holding of Dole was that this spending clause provision was valid, that only 5% would be withholding, was not coercive, and it related to the federal general welfare, and it related to the interest of highway safety. So it was close enough, in the ballpark. The O'Connor dissent said was not close enough, but she only had her one voice and one vote. All right, other questions on Dole? Again, and O'Connor doesn't say it, but the reason why she found the law unconstitutional was it violated the necessary and proper clause. She didn't actually say it, but effectively what she's saying is this was not a necessary and proper means of executing Congress's power to regulate interstate highways, for example. She didn't say that, but that was the basis of her opinion. Okay. All right, let's go to the next case. U.S. versus Lopez. U.S. v. Lopez was a 1995 decision. And I want to just give you some background, right? If you had gone to law school in the 1960s, 1970s, 1980s, early 1990s, you were taught that there are no limits on federal power. That if Congress enacts a law, it's valid, right? That if Congress decides to regulate local activity, they can do it. The court was no longer in the business of second-guessing the judgments of the legislature. You have been taught that, and I think that would have been an accurate statement of law. Right? I think that would have been an accurate statement of law in the 1970s, 80s, and 90s. Not everyone agreed with that, though. Right? There was always a dissenting voice about whether Congress, in fact, had that much power. And that brings us to the case of Alfonso Lopez, who went to Edison High School in San Antonio. Anyone from San Antonio know Edison High School? No? No? It's a big town, right? I don't know. All right. I'm sorry. Nick, you want to give me the facts on Lopez, please?
Yes, sir. Mr. Lopez was a high school student who brought a gun to school, and that was in violation of a congressional act.
What else did it violate?
State law.
It did. Where was he initially charged, Nick?
In the state of Texas.
Okay, but then what happened to a state charge?
They dismissed him and passed him on to.
Why do you think that the district attorney in San Antonio, Behar County, right? Why do you think the DA in San Antonio decided to dump the case, let the feds take it?
Cost.
Yeah, it's free, right? The local police get all the glory of arresting a kid who brought a gun to school. I think he was 18 at the time. I don't think he was a kid, but you know, a student brought a gun to school, and they don't pay for it, right? They let the feds prosecute. They let the feds incarcerate him. If there's any sort of supervision, they let the feds supervise him. It's all too common for state police to hand cases over to the feds. They get all the glory, all the fame, and they don't have to pay for it, right? No work. It happens all the time. A lot of drug cases start off as local, drug buys, and they turn it over to the feds, and you go away for a much longer time. But Texas had a law in the books that prohibited the possession of a gun in a school zone. So we didn't need the federal law. But in fact, he was charged under the federal law. And this federal law made it a crime to possess a handgun within so many feet of a school zone. I remember these laws when I was a kid. You had these signs over a gun-free school zone in New York. I remember these signs popping up in the 90s. Now, is that Jonathan? Jonathan, if you were Alfonso Lopez's lawyer and you were advising him, what would you recommend he do with this case? He had the gun in school. There was no doubt he did it. He violated the statute. What would you have advised him?
Are we assuming that it's in the state, or are we in?
No, you're in federal court.
Then that it violates the Commerce Clause.
Is that what you would advise him?
Me? Well, that's what they advised him.
I'm asking you, if you were you were a public defender. You're a public defender. You have a docket of cases this high, and you know if your guy goes to trial, he's looking at serious jail time. What do you advise the guy?
I probably would have told him that he didn't knowingly bring the gun.
Mens rea, it's covered. He did it. He brought it. He knew he brought it.
Okay.
How do most criminal cases wind up? Do they go to trial?
Can he get convicted?
Oh, he's going to be convicted, but what?
I would have took a plea.
Take a guilty plea, right? Exactly, right? Almost, I don't know the number, but it's in the high 90s, 97, whatever the number is. The vast majority of criminal cases do not go to trial. The defendant takes a guilty plea. What that means is they confess guilt in exchange for a reduced sentence, right? In exchange for reduced punishment. So maybe instead of jail time, he gets probation for first-time offense, whatever it happens to be. Maybe he pays a fine or something reduced. Now, again, if you decide not to take the guilty plea, the prosecutors don't like that very much, and they throw the book at you, and they'll seek mandatory jail time. I think, Michael, you said you're in criminal justice or something? Mm-hmm. Yeah, I mean, that's usually how it goes?
What's that?
That's usually how it goes?
Oh, yeah.
Yeah. They'll throw the book at you because they don't want to go to trial because it's too much work for them, right? And the judge will say, oh, why are you wasting my time with this, right? And he'll maybe give you a sentence in jail. But the lawyer in this case, I looked up his name was Jack Carter. I emailed him years ago. I didn't reply. He might be retired. This is some years ago. But he was a public defender in San Antonio. Let me tell you, public defenders do the Lord's work. It's important. You want to do ConLaw, right? You want to do constitutional law? Become a criminal lawyer. The 4th, 5th, and 6th Amendments are very important, right? Not everyone works for the ACLU or the NRA or Planned Parenthood. This is actually ConLaw as well. But his lawyer said, you know what, Mr. Lopez, I'm going to recommend you not take a guilty plea. I'm going to recommend you challenge the constitutionality of the Gun-Free School Zones Act, a massive law that just passed with bipartisan majority. Bill Clinton backed it. I mean, this was a big law. Risky, right? Because your guy can go to jail. He could have just taken a plea and maybe a reduced sentence. I don't know. But Mr. Lopez decided to roll the dice. And at the time, imagine you're in an interview. Lopez goes, so what case is it relying on? Well, we got some stuff from before the New Deal, right? Right? It's like, is there any actual precedent? No, well, we got to go back to the 1920s. We got some good stuff there, right? It's amazing that he went along with it, but he went along with it. And it worked, right? He actually prevailed in the lower courts. And this case goes to the Supreme Court. And the question is, does Congress have the power to enact the Gun-Free School Zones Act? This was the first case in, 6 decades, 60-something years, where the court actually found that Congress exceeded its powers under the Commerce and Necessary and Proper clauses. It was a huge case. Lopez, I don't know if he was prosecuted on remand under state law. I'm guessing the statute of limitation ran because they dismissed the claim. So I'm guessing they had to just dismiss it. I don't think he was retried under state law. I'm pretty sure he wasn't. I can double check that later. I think by dismissing the charge, I think that they lost it under state law. They let the guy walk. But he prevailed. Okay. So that's like the big happy ending story. Like Lopez got out, right? But the way they got there is complicated. The first question we have to answer for Mitchell. Does Chief Justice Rehnquist overrule any of the New Deal precedents, like Jones and Laughlin Steele and Wickard and Darby and those cases? Does the court overrule anything?
I wouldn't necessarily say overrule, it's more disagree.
Does he? Does he actually say the cases were wrong? No. So how does he treat the New Deal cases? Does he cast doubt on them, or does he say they're incorrect?
For lack of a better word, he kind of just slows down the expansion of power.
Slows down. Okay, I could go with that. What do you mean he slows it down? Just walk me through what you're thinking there. I think you're on the right track.
So the Jones, Laughlin, Steele, Darby, and Wickard greatly expanded the authority of Congress. And
Okay.
so he kind of acknowledges that Congress may have too much power.
Okay, but here comes the but.
But
Yeah.
it's okay that Congress has that amount of power, but that's where I got stuck.
Okay, well, let's take this one step at a time, right? Very often, Lopez is criticized for reversing the New Deal, and I don't think that's a fair criticism. Rehnquist is very careful not to restrict is the wrong way. Very careful not to disagree with these sort of doctrines developed in the 1930s. He basically says, those cases expanded the scope of federal power, right? They expanded the scope of federal power. Maybe those are right, maybe those are wrong, I'm not going to say. Thomas says for sure. Thomas tells us what he's really thinking, right? He always does. But the majority is like, look, we have these decisions, they expanded federal power. Okay. But there were limits on what they did, right? What Rehnquist does is he identifies limits that can be found in these old decisions. Okay, now, these old decisions never admitted such limits existed, right? What Rehnquist is doing is he's finding in opinions parameters, borders that can be identified. Do those opinions actually have those parameters? Not really. This is Rehnquist's way of limiting precedents without saying so, right? He's saying, here are limits in these cases which no one's ever noticed before, right? That for 60-something years, everyone thought these cases meant, do whatever the hell you want, right? But no, but that's not what they said, right? And in Lopez, Morrison, and Raich goes the other way, but in Lopez and Morrison, the court finds limits and says it's not unlimited. There are restrictions. Everyone understand that, right? So he's not overruling Laughlin Steele and Darby and Wickard. He's simply saying that those cases aren't as broad as we thought for 60 years. Let me tell you, this case came as a shock to law professors. They were livid. They're, oh my God, the New Deal, the administrative state's going to collapse tomorrow. And really all that happened was this little silly law that guns was declared unconstitutional, and then Congress reenacted it 5 minutes later. We'll get there in a bit. I mean, these sort of like apocalyptic decisions had such a trivial effect on our country. Very, very small. All right, compare that with like the New Deal case, which blew things up. Okay. All right, Amy, so let's walk through this one step at a time, right? Rehnquist identifies 3 broad categories of activity, and that's a key word, of activity. Keep in mind the word activity when we do Obamacare. Rehnquist and Roberts, they put a lot of weight in the word activity. 3 categories of activity that Congress can regulate under its commerce power. And let me just pause here. Rehnquist says only commerce power. He means necessary and proper as well. He doesn't mention it. He's talking about necessary and proper. It's very frustrating. So Amy, what's the first category of activity that Congress can regulate under its commerce power?
I know one of them was manufacturing.
No, the 3 categories.
Oh wait, say it again?
There were 3 categories Rehnquist identified.
I don't remember.
I'll give you a hint. First one begins with the letter C.
The what?
The first one begins with the letter C.
Channels of the interstate commerce.
Okay. What are the channels of interstate commerce?
The going on.
Okay, very good. Right. Congress has the power to keep the channels of interstate commerce free from bad stuff. What are these channels? Think of roads, right? Highways, rivers, streams, right? Congress can regulate a hotel in Atlanta because it's part of an interstate travel system, right? That a hotel is part of this interstate channel of commerce, right? So he talks about these channels of interstate commerce. Okay. Kyle, what's the next category Rehnquist identifies?
Regulate the instrumentality of persons or things using interstate commerce, even though for those things that may interfere with commerce may be interstate.
Very good. Kyle, tell me, what the hell is an instrumentality? Rehnquist doesn't define it, which makes me very frustrated. What's instrumentality?
They would say it would apply to the act, right?
Well, he says it doesn't, but in general, what's an instrumentality in general? What does that word mean?
Well, for commerce, it could be, I don't know, somebody damaging the road in some way. It could be.
It's not a channel?
Huh?
It's not a channel?
Oh, you mean? Oh, I thought you just said instrumentality.
Yeah, what's
You
an
mean instrumentality of channels?
what's an instrumentality of commerce?
Vehicles.
Okay, close. Examples that Randy I can think of: a port, like the Port of Houston, right? If you damage that, you're damaging something that could affect commerce. Railroad tracks, maybe, right? These are things that enable commerce to move forward. For the life of me, I don't know the difference between the channels and instrumentalities. I think they're the same damn thing. I've been teaching skates for years. I always get them confused myself. Is it a railroad or a highway? I don't know. The C and the I are basically the same thing. I can't really distinguish them, but Rehnquist seems to find there's a difference. Whatever. Okay? The one that actually matters, right, is the last one. You can actually remember them with the acronym CIA, which is how I, right, the channels, the instrumentalities, and the last one, right? That's how I remember them. And Braden, what's the last one, the third category?
Activities.
Okay, specifically, very good. What kind of activity, sir?
Having substantial relation to interstate commerce.
Yes, this is the substantial effects, right? Right? Substantial effects. Congress has the power to regulate intrastate activities that substantially affect interstate commerce. Right? This is from Darby and Wickard. Right? Congress can regulate local interstate activity as a necessary and proper means of regulating interstate commerce. Right? Congress can prohibit the growing of local wheat to prevent that cheap wheat from growing onto the marketplace and distorting prices. Right? This is where all the action is, right? The channels and instrumentalities is actually fairly straightforward. They actually have some relation to interstate commerce, right? But here we have entirely local activity. Entirely local activity that has a substantial effect on interstate commerce. Right? Now, are these three or two, depending on how you count, are these three categories identified in previous cases? Not really, right? The only one that actually matters is the last one, which is a substantial effects test, right? He's not overruling Wickard and Jones and Laughlin Steele. All he's saying is, does the Gun-Free School Zone Act come within the scope of Wickard, right? Does the Gun-Free School Zone Act come within the scope of Jones and Laughlin Steele? That's all this case is asking. Right? These three categories are pretty stupid. I give them to you because it's in the case, but like it doesn't actually add anything. Right? Everything's on the third factor, right? Is this an activity that has a substantial effect on interstate commerce? Okay. Look, yeah.
Would it be fair to say he's basically streamlining what the New Deal cases are?
I'm not sure what streamlining means. Maybe synthesizing is a better word. He's like trying to consolidate, but I mean, it doesn't really add too much. That part. But the next part is huge, right? The next part is huge. He makes a move, a very subtle move, but an important move. He says, I'm going to modify this a little bit, that the activity must be economic. That the activity, the local activity, must be economic. In other words, you can aggregate together economic activities, right, on Wickard. All the people growing crops, growing wheat. But you cannot aggregate non-economic activity, like bringing a gun to a school, right? So this entire case turns on whether the act of bringing a gun to a school is economic. All right. Now, who's next? Oh yeah, I'm sorry, Kimberly. Kimberly. Now you read Wickard, a couple days ago. You read Jones and Laughlin Steele a few days ago. Did those cases say anything about the activity being economic in nature?
No.
So where did Rehnquist get this from? Did he make it up?
He didn't make it up, but he kind of gathered it or inferred it
Sorry.
in these cases because those activities were economic even though they didn't say it. So he just kind of created this addition to it.
Is that addition? I think that's a good word. Do you think this is a fair reading of Wickard and Jones and Laughlin Steele to have a requirement that the activities be economic in nature?
I'm undecided on that. Maybe.
You're undecided. Okay, just speak out loud. Show me what your thinking is. I want to see what's making you on the fence.
Because, well, I think the problem here is that he doesn't define what an economic activity is. So that leaves it open for a very broad definition.
Which would be Raich, wouldn't it? Okay, I think you gave me a very good answer. So let me try to unpack that a little bit. Rehnquist is trying to put the brakes on the expansion of federal power, right? He's trying to, you ever go on a train and that little, like, that red thing, you pull at the emergency brake and the entire train crashes to a halt? Okay. He's not pulling the emergency brake, right? He's just slowing the train down a little bit, right? He's simply saying, okay, we're not going to go off the tracks, but we're going to stay on the tracks at a much slower speed, right? And the way he does this is by saying, all the cases we've studied, Wickard, Jones and Laughlin, involved local activity that affect interstate commerce. But in each of those cases, the activity that was local was economic in nature. You know, in Jones and Laughlin Steel, it was the manufacture of steel. In Darby, there were lumberjacks, lumber workers. In Wicker, they were growing wheat, right? Ollie's Barbecue, right? It was a commercial restaurant that was selling food, right? Every case involved activity that was economic. Therefore, Rehnquist says, you can only aggregate, add together, economic activity. If it's non-economic, doesn't fit into the A, right? But again, that wasn't in Wickard. That was not the holding of the New Deal courts. So the Rehnquist court made a new holding, which, addition, I like Kimberly's word. I think addition is a good word. It added another layer. And the way Randy explains it is like a dividing line. It said, look, we went really far in the New Deal. We're not going to reverse those cases, but we're not going to go beyond them, right? Unless you can give us some sort of principle to limit federal power, right? If Congress can regulate any activity in human existence, there is no limit. So we're going to give you a limit. And our limit is economic activity. You can only aggregate economic activity. You cannot aggregate non-economic activity. Okay.
Is this why
Where's your hand first? Yeah.
Is this why Obamacare keeps surviving? Sort of because they keep arguing that it is economic activity?
We'll do Obamacare next week. Okay. So everyone get that part of the opinion. Yes, sir, Mitchell.
So I don't know if I'm getting ahead, but I remember they were talking about like basically everything can be considered an economic activity where if you allow people to bring guns to school, people won't prosper in school, and therefore it'll have a direct effect on the economy.
Right.
So is this just kind of like putting some cones up in a field and saying don't go past those, or is it like an actual going to be a line?
Well, that was the huge question, right? Was this an actual line? Justice Breyer's dissent, who I don't think is in your book. It's not in your book, right? Justice Breyer's dissent, is it?
Yeah. Sure.
Oh, okay, good. I always forget which dissents are in there. I never remember. The Breyer dissent, I think, argues what Mitchell does. Look, he says, if people bring guns to school, then students won't learn well. And if students don't learn well, then they will be uneducated. And if they're uneducated, they won't get jobs. And if they don't get jobs, they will be unemployed. And if they're unemployed, they'll impact the economic market nationwide. So therefore, Alfonso Lopez's decision to bring a gun to school affects interstate commerce. It's economic activity. And the court rejects that. They say, no, that's not how we do business here, right? You're taking one inference, and you're piling on a second inference with a third inference and a fourth inference, right? No. It's not whether this activity will have an economic effect. It's whether the activity is economic itself. Right? And merely possessing a gun and bringing it to school is not an economic activity. But Afosa, where did that gun come from?
The one that Lopez actually had? Or
Yeah. Where did Lopez's gun come from? You don't have to know for sure, but take a guess. Just a guess. Did guns just magically appear in his backpack? I mean, where did it come from?
I guess he bought it.
Maybe. Well, he probably didn't buy it. He was underage, but someone bought it, right? Right. I think he was not 21, so someone bought the gun, right? And do you think the gun was manufactured entirely in Texas? Just a guess.
Maybe.
Do you think all the steel in the gun came from Texas? Do you think the wood in the handle came from Texas? The gunpowder came from Texas?
So he's arguing that the materials used it came from another state, which involves interstate commerce.
Good. What case is that? What case we say last week? Or last class, I should say. Remember?
I know.
What did it? I don't need the name. What did it involve? I'll give you the name.
I know that a restaurant.
Yes, the barbecue. Ollie's Barbecue, Katzenbach, right? Katzenbach held that even if you have a local restaurant that only serves customers in one state, Congress can regulate that restaurant because their food, their appliances, their equipment travel from out of state. So Michael, why couldn't the court just say, look, Lopez's gun came from out of state. That's good enough. Why did that argument not work here? Why couldn't the government use that argument here? Well, let me ask this question, Michael. What exactly did the law prohibit, the Gun-Free School Zone Act?
Guns in schools.
Okay. Did the law say anything about where that gun has to come from? What if what if Congress had specified that the gun traveled interstate commerce?
Would they be able to specify?
What if they said it's a crime to bring a gun to a school zone where the gun had traveled interstate commerce? Could Congress pass that law?
I'm not sure, because how would they know?
Well, the gun was manufactured in Kansas. I don't know. Angela, could Congress have passed that law that says you can't bring a gun to a school zone if the gun had traveled interstate commerce? I'm sorry? Yes. How do we know that?
Because they did.
They did. Exactly. They did. Perfect, right? They did it. As this case was pending, right, Congress basically reenacted the same law with an additional sentence. I'm not joking. And the additional sentence said, it's a crime to bring a gun, I'm paraphrasing, to a school zone if the gun traveled interstate commerce. That's Ollie's Barbecue, right? That's Katzbeck and McClung. This entire case was remedied by a single sentence in the US Code. Just one sentence saying, yep, traveled interstate commerce. So I mean, Lopez couldn't be prosecuted because his offense occurred before that law was enacted, right? You can't ex post facto. You can't prosecute him after the fact. But Designate, let me ask this question. Is this case stupid, right? Is this, all cases are stupid, right? You have to read them, right? But is this, but I mean, is the Supreme Court just being a bunch of like sticklers, just like, ha, you didn't check all the boxes, right? If we know that Congress could have enacted the same law by adding, 5 extra words, why do this court decision say, aha, you can't do this, right? Why not just say, well, we could assume Congress wanted to regulate guns from out of state, so that's enough. Why is that? Is this a stupid opinion? Like, what do we make of this?
It's not a stupid opinion. I don't know why, but I mean, it's not.
But let me ask a question differently, doesn't it? Shouldn't Congress just get some leeway, get some slack, right? Why shouldn't the court? Okay, you say no, they should not get slack. Why?
Because if they get slack, then they'll make laws and say, well, we meant this, or assume that we meant this about other laws that they put a bar on.
So they're being lazy, in other words, right? Okay. This is often called the stupid staffer problem, right? The staff member, right? The stupid staffer. It's called different things, right? Congress got lazy here. Had they just added one sentence to this law, it would have been fine. But they forgot or they didn't care. And they probably didn't care because for 60-something years, the court didn't really intervene in these matters, and they just got lazy. And the second this case went up to the Court of Appeals, they reenacted the same damn law with an additional sentence on it. All right? But at a minimum, the court's saying here is, you can't be lazy, right? Congress, if you want to regulate local gun possession, you have to connect it to interstate commerce. You can't rely on the courts to bail you out. We're not giving you the slack. We're not giving you that leeway. And that's why the decision was so important, right? Usually the test is deferential, right? They say, we don't need Congress to check all the boxes. We'll just assume they did, right? We're going to just generally trust them on this one, right? Did we actually know that that Roscoe Filburn's wheat affected interstate commerce? No, but we can assume it would, right? It's about is there a rational basis on which we can assume this is valid? Yeah, okay, we're fine. But here the court says you need to check the boxes, right? You need to make findings about how this local gun possession affects interstate commerce. Okay, so I don't think it's a stupid opinion, for whatever it's worth, but I appreciate you answering the question. It's like, oh yeah, all these cases are dumb, I have to read them, right? Yeah, Nick.
Just to be clear, by adding these extra words that the gun comes from interstate.
Yeah, the gun travel interstate commerce is a specific phrase you have to use. This is the jurisdictional hook. Remember the herpes theory,
Yeah.
right? This is the jurisdictional hook. Yeah.
My question is, does that phrase kind of circumvent the need to show economic
Yep.
activities, or does it
Yes.
itself show economic activity?
No. This CIA thing is only about local activity, right? You're regulating a local hotel or a local restaurant or a local gun. But once you show the gun travel interstate commerce, you're actually regulating the gun itself.
Okay, so it goes
Right?
around the-
Right. When you show that the gun travel in interstate commerce, your law is not just regulating Lopez, it's regulating the gun itself, and you can regulate how the gun is used.
Moved it back.
You want to say we want to get these illegal guns out of the channels of out of the interstate commerce market, and we're going to do that by banning it. That's actually my next point, right? Let's say that Ray, let me ask you a question, right? Does Congress have an interest in eliminating, guns being sold to minors nationwide?
Yes.
Yeah. And let's just say, let's say that Texas allows minors to buy guns and bring guns to schools, and then people start shipping, all these guns to Texas, which kids bring to schools. Is that a problem that Congress might be worried about?
Yes.
Okay. So why couldn't Congress say, look, we have this national problem of all these guns being shipped to Texas. In order to deal with this national problem, we need to strike at the core. We need to ban the local possession of guns, right? Right? We have this broad regulation of national activity, but we need to go local. Could Congress do that? Right? Right? Let me ask the question differently, right? I asked the question poorly. Can Congress ban the sale of firearms? Forget the Second Amendment for a second. Could Congress ban the sale of firearms to 18-year-olds in Texas?
No.
You say no. Why?
I believe it's something that the state has the right to implement.
Well, couldn't Congress ban the growing of wheat in one state?
They did in the next state.
But so then why couldn't Congress ban? No. Deal with me, right? Why can't Congress then just, instead of banning the sale of wheat, they can just ban the sale of guns to minors in states? Why can't Congress do that?
Well, they can if they have already something, national or federal.
They do. Congress has a national scheme that says we do not want minors having guns, right? And they say in order to effect that policy, we're going to ban the local sale of handguns to minors. Could Congress make that law?
Yes.
Okay, I think everyone's right. I think that's right, okay? Forget the Second Amendment for a second, right? As a matter of the Commerce Clause and Necessary and Proper Clause, if Congress has this national scheme to keep guns in the hands of minors, they can then regulate a local activity, the sale of guns to minors. But here's the rub. Ready to finish it up. Is the sale of guns economic?
Yes.
Yes. Right? The possession of handguns, not. So Congress can still reach local activity that's part of this national scheme, but they cannot reach activity that is non-economic. In other words, Congress can only regulate local economic activity, like buying a gun. They cannot regulate merely possessing it, unless you show that the gun traveled interstate commerce, right? And that's a key part that will become important later, right? And I'll just give you a preview to Raich. In Raich, you have a national policy to keep marijuana out of the hands of people, right? Can you prohibit the local growing of marijuana? The court says yes, because it's economic, right? And that's part of a broader regulatory scheme, right? You have this broader economic scheme, therefore you can regulate this local activity. Yeah.
Is that kind of like, I'm in First Amendment right now, and we're talking about obscenity?
Yeah? Well, you're doing First Amendment at the same time as ConLaw?
Yes, I am.
Why? Are you the only one?
Yes.
Why would you do that?
Because I took some classes and I failed. So.
Oh, I wouldn't recommend that at all. Okay, too late. Okay. It's you're okay. Go ahead.
Anyway, so we just read the case about the guy that had the possession of like hardcore pornography.
Stanley v. Georgia.
Yes.
Yep.
So is that kind of like the same thing? Like you can't make it, but having the mere possession of it.
Well, that was a state prosecution case. That was a Georgia case. But yeah, there's a difference between possessing it and buying and selling it. But there's generally, why does the state have the power to criminalize possession of drugs? It's actually a fairly difficult question, right? Why can Congress criminalize mere possession? Right? You're not buying or selling it. And the simple answer is because it relates to buying and selling. That in order to stamp down the illegal sale, they can regulate the possession. But generally, making possession a crime is actually a lot tougher because you're not doing anything with it. Yeah, good point. Yeah, I mean, you're learning scrutiny way ahead of schedule. It's gonna be a little confusing. You're actually gonna be very confused because things are different here and there. But okay, never had someone take ConLaw and First Amendment at the same time. That's a new one. First Amendment's required now. That's new. So you might have me again, Lord help you, right? Not this year, maybe next year. It's fun. Very different class. Very different class. I've had the same students 3 times in a row. I remember Property 1, Property 2, and ConLaw. I've had some, voluntarily they took me again. Imagine that, right? It happens. Okay. All right, so everyone get this element, right? So it's commerce and necessary and proper clause. Doesn't go that far. The Gun-Free School Zone Act has nothing to do with commerce. I'm sorry, economic enterprise. And it's not part of a large regulation of economic activity, which allows the regulation of local conduct. Therefore, it does not fall within the substantial effects test. Okay. At bottom, the court recognizes there has to be some difference between what is local and what is national. We cannot obliterate the distinction between the two. This comes from Jones and Laughlin Steele. All right, any other questions in the majority? It was, this mountain and a molehill. There's like this huge decision that had almost no impact because Congress reenacted the damn law. Yes, sir.
It was monumental just because it was a 60-year.
Yep.
Thing that everybody just overlooked.
Yeah, it's like you have a 6-year winning streak and suddenly lose is like a big deal. Yeah, Braden.
This is about Breyer's dissent.
Oh, sure. I was going to get there in a minute, but you're welcome to ask about it now.
It's the Hawaii principle on inference, and he says that there's limitations to it, so he doesn't specify how. So I'm just if you were to get in the head of Breyer.
Oh my God. Oh my God. Oh my God. Oh my God. Get into the head of Stephen Breyer. I mean, he's one of the most. I've come to appreciate Breyer. He's a pragmatist, and he likes things that are functional. He worked as the chief counsel for Senator Ted Kennedy in Massachusetts for a number of years. He's an administrative lawyer. He thinks about how to make government work most effectively. And he generally says we should always defer to government unless it involves abortion and a few other things, right? When it involves abortion, we can strictly scrutinize it, but everything else we defer. Breyer has no problem with making inference upon inference, saying, well, if Congress could have thought about this, then it's enough. But if you actually go to the arguments in Lopez, if you watch our video, I'll play it so you could might answer Braden's questions. Where's it? Yoshi Lopez, okay. No, that's not it. There was one scene, not scene's the wrong word, I'm making movies, but there was one exchange during the oral argument where the lawyer for the government was asked, what are the limits, right? In other words, if Congress can regulate local gun possession, what can't they do? And this is what's called a limiting principle, right? What's your limit? This is Braden's question a minute ago. And the lawyer for the government really had no answer, because if you take the New Deal cases seriously, if you take Wickard seriously, there really is no limit. And so here the court tried to make one up. So again, I think the court made it up, to be frank, but it was actually a limit that they had to make up, because there has to be some limit.
During oral arguments, Justice Ginsburg asked the Solicitor General,
what are the limits then? What would dictate that would fall outside?
And the Solicitor General, by the way,
comfortable pause to reply.
The Solicitor General is the lawyer for the U.S. government, the top lawyer. So let's just put back a little bit.
Justice Ginsburg asked the Solicitor General,
What are the limits then? What would be a case that would fall outside?
after an uncomfortable pause, he replied,
I don't
Justice Scalia then interjected.
give away anything here. They might want to do it next.
The inability of the Solicitor General to identify a limiting principle to its theory of congressional power was fatal to the government's argument. By a vote of 5-4.
And that's basically the outcome in Lopez, right? I think Brand's question gets at this well. If you can do the Breyer thing, right, where you just say, well, if this happens and this happens, if this happens and this happens, there's no limit. Now the dissenters, if you probably gave them something to drink and had a nice chat with them and say, yeah, there are no limits, right? That's the New Deal court held, right? The New Deal court held they can do whatever they want. But you still have Jones and Laughlin Steele, which said there is a limit. And so the Lopez court tried to find some limit. We'll see in Raich, the limit was sort of blown open in a couple of years, because I think Angela or someone else said a minute ago, it was Kimberly, right? They don't define economic, right? So the court blew it up. But that was Lopez. We have a concurrence from Justice Kennedy and Justice O'Connor, and they recognize that there are areas for the states to regulate, that there's some division. And here, you need to have boundaries. Sergio, let's talk about Justice Thomas's concurrence. Justice Thomas is the most idiosyncratic justice in that he does not give much regard to the concept of stare decisis, that is standing by precedent. He is fully committed to reconsidering any precedent that's inconsistent with the Constitution's original public meaning. He's very committed to this cause. People always said, oh yes, Thomas followed Scalia. It was the other way around. Scalia would joke that he follows Thomas. Thomas was actually far more advanced than Scalia ever was, and Thomas is still leading the pack. He's still a young man. He's like 72. He may be in the court. I think he'll be in the court another 20 years. He will break the record, I think, for the longest serving justice. He was appointed when he was like 42 or 43. He was a fairly young man, so he will be on the court for a very long time. But Sergio, what's Thomas's concurrence? Just walk me through his point.
Thomas has I guess you could call it an originalist, like Madison type of view.
Okay.
So to him, he would take it back, like you said earlier, to pre-New Deal. So basically, that we need to change the way that we progress the Commerce Clause.
Yeah. Thomas would revisit the New Deal. He said this many, many times. Thomas has stated that the Commerce Clause says you regulate commerce, not economic activity, right? The entire idea of saying, is this economic activity, is sort of irrelevant to the text. The text doesn't say that Congress can regulate economic activity that affects interstate commerce. It says they can regulate interstate commerce. So if you have the CIA, Thomas will kill all of that. You say, look, is this interstate commerce? Yes. Okay, you can regulate it. No, don't. Now, if Thomas's position was taken seriously, then huge chunks of the modern administrative state would be invalid. And he would say, so be it, if you had to ask him, right? He would say, amend the Constitution otherwise. All right. There were several dissents. I think we already mentioned the Breyer one. But the dissents were by Justices Stevens, Souter, and Breyer. And they focus on what we call judicial restraint, or what you might call deference. He said that the court should not second-guess Congress's decisions. That if Congress thought this law was a good regulation of interstate commerce, then that's enough for him. Even though Congress said nothing about interstate commerce, they should defer. Okay. So any other questions on Lopez? Lopez was a huge case, again, because it was the first time in 60 years that they had this decision. But also, there was a question like, did they actually mean it, right? Were they actually going to start declaring laws unconstitutional for going beyond the commerce powers? The next case shed a little bit more light on this, but not very much. Matt, you want to give me the facts, please, in United States against Morrison?
Yes. This related to the Violence Against Women Act, which had been passed by Congress prior to the Lopez
yes.
decision.
By the way, this was Joe Biden's like crowning achievement. This was like his signature legislation. Go on.
So there was a young woman who brought charges in federal court against a couple of Virginia Tech football players who she had accused of raping her, and because the state had not brought charges.
Okay, so when you say brought charges, what does that mean? I mean, individuals cannot bring criminal charges. Like I can't like 3 in jail. I'm not allowed to do that as a private citizen.
Right.
So the state didn't bring any criminal charges against these 2 football players. So instead, what did she do?
So instead, she argued when the state or the federal prosecutor argued that it was a gender-based violence that she.
Okay, very good.
Right. The
Very good. Okay, very good. Thank you.
That conduct.
Okay, very good. So VAWA, the Violence Against Women Act, VAWA. And by the way, it's not just violence against women, it's all gender-motivated violence. If you have a woman beating up a guy, it works just the same, right? VAWA was a huge law. It did a lot of things. It affected immigration. So let's say you were in this country and you were not a citizen and your spouse was beating you up, that might be a way to get citizenship, right? You can get petition for green cards, right? So there are different ways that VAWA tries to remedy gender-motivated violence, right? Generally, if a person commits a battery, right? Sexual assault is a form of battery. I can go to a state court and I can sue them for damages, right? We all know that. Can I go to federal court and sue them? Well, perhaps if there's diversity jurisdiction, right? Someone from out of state batters me, I can go to court and sue under a tort and diversity. But what if there's no diversity jurisdiction? Well, in this case, she was assaulted by 2 individuals at the university in Virginia. She could not go to federal court in diversity. Instead, she had to rely on what we call federal question jurisdiction. And here, Congress created a federal cause of action. And federal cause of action says if someone engages in gender-motivated violence, you can go to federal court and seek damages. Now, do you think there's much point in suing 2 college football players? By the way, they never made it pro, right? Of course not. They have no money. They don't have deep pockets. Who did you really want to go after? The university. Virginia Polytech. Virginia Tech, though, was a state institution. And what do we know from the 11th Amendment, Josh? Can you sue a state institution, like a state university in federal court? No, unless when can you sue a state institution in federal court? Oh, actually, I'll give it to you. We haven't said this yet. Congress can waive a state's sovereign immunity, right? I'll come back to you. Sorry, that was an unfair question. We haven't done this yet, right? Generally, you can't sue a state. I have to remember where we are. Generally, you can't sue a state in federal court unless Congress allows you to. Congress can peel back a state's sovereign immunity. So Christine Brancala, actually, she said Brancala, the Z is silent. So Christine Brancala didn't just sue the 2 football players. She sued Virginia Polytech, right, the college, in federal court because she wanted damages. Because under the federal law, you could sue a state institution in federal court. Now, she relied on this gender-motivated cause of action, right? Now I'll come back to Josh. Josh, did Congress have the power to enact this gender cause of action?
No.
Okay, tell me why.
Because the court held that the violence or the act itself wasn't economic in nature, so they didn't have any place to it.
Okay, very good. So the holding in Morrison was that gender-motivated violence, here sexual assault, right? Sexual assault is not an economic activity. Sexual assault is not an economic activity. Therefore, Congress cannot regulate it under the Commerce Clause, right? You can only regulate local activity when it's economic in nature. Now, if you recall, with the Gun-Free School Zones Act, they were lazy, right? They didn't say anything about interstate commerce. Facts here are different, Hannah, right? How are the facts a little bit different here?
Sorry, can you repeat that?
In Lopez and the Gun-Free School Zones Act, the court said nothing about interstate commerce. How is VAWA different?
Not sure.
Ethan?
I think it's different in the fact that it's involving people instead of.
Well, let's talk about the legislative process, right? How was the legislative process different? We said in Lopez they were lazy, right? Congress didn't mention anything about commerce. Why is VAWA a little bit different?
Congress included more information on how it related to interstate commerce when they were.
Exactly. Congress made what are called findings. Findings. What are findings? They're provisions of law that say, we, Congress, find X, right? We find that women who are abused in these relationships create a national problem, and that women who aren't able to seek damages for these acts of violence aren't able to participate in the labor market, right? We find that this local activity does have a substantial effect in interstate commerce. So look, with the Gun-Free School Zone Act, they were lazy. They didn't do their job. But with VAWA, they tried to do everything in their power to show the connection between gender violence and the interstate market for labor. Matthew, was that enough to save the law?
No.
No, why not? Why does Rehnquist, again, the majority, it's the same 5-4 split, right? Why does the majority say that's not enough? Why doesn't it matter? All of Joe Biden's hard work, right? Why does none of that matter?
Because it's not economic.
Bingo, that's it.
Yeah.
Doesn't matter. So they made a really big fuss about the lazy, stupid staffer in the first case, but actually then that didn't matter, right? Because in this case, they actually had the legislative history. They actually developed the record to show the effect on commerce. But because the local act was not economic in nature, Congress was out of luck. Therefore, the VAWA provision, the cause of action provision, was unconstitutional, and Chrissy Brancala lost her case. And the court basically says, look, if this is a big problem, the state can handle it. And we know the state didn't handle it. And I mean, we can give you an insight why. These were football players in a college town. You can suspect the police didn't want to prosecute one of their own. And I think the students were given a slap on the wrist. They wouldn't have to miss a game. So that, you know, that happens. And here she had no remedy. In federal court, she could have gone to state court, but she could not have sued the university in state court. And she sued the football players. She got their judgment proof. They have no, you know, they never made it pro. I don't know whatever happened to them, but you know, they were not going to give her any money. Okay. Yes, sir, Matt. Well, yeah, you're. But what you're suing over is the actual injury, right? It's not the lawsuit. Yeah, cute. Yeah. Yeah, I'm suing for damages, economic activity. No, it's the actual, it's the actual thing you're suing over that has to be economic. But I appreciate your creativity.
I tried.
Yeah, no, it's always good. Okay. Any other questions on U.S. v. Morrison? All right. Last case. For today, at least. Not for the semester. My God, we have at least 100 to go. We have a 90-something to go. What is it? Yeah. So the last case is Gonzales versus Raich. And Randy makes me fuss. It's Raich. Not Raich. Raich. Like R-A-Y-T-C-H. Raich. Okay. Got that out of the way. And this is an important case for Randy because he actually argued the case. Oops.
Wasn't that his co-counsel, the husband of Raich?
He was, yeah.
Yeah.
Yeah. 1 second. All right. 15, 1 second. Something's out of whack. 26. Sorry, one thing's. All right, so Randy argued this case. And by the way, Randy maintains, and I believe him, he never smoked marijuana. I've never done it either, but Randy actually believed because he says it makes it more credible that he can now say, look, I support marijuana, but I've never actually smoked it, and I do believe him on this one. He came across this case somewhat indirectly. During the mid-90s and late 90s, states began to legalize medicinal marijuana. Now, I put the hashtags up, or the scare quotes up, because basically anyone who had a condition will get a doctor's note to get the pot. So it wasn't like actually medical, but it was designed to give people legitimacy. And the people of California actually approved a referendum to legalize medicinal marijuana. The problem, of course, is that the federal government still made it a crime to possess this controlled substance. The mere fact that the state legalizes pot doesn't mean it becomes legal under federal law. And in fact, even in Colorado and other states where it's now legal, the feds could prosecute. They haven't, and I have actually serious issues with that. We are just not enforcing our drug laws. I don't like them, but I think they should be enforced. This is where Randy and I perhaps disagree a little bit on this one. But they have these drug laws. Randy was hired to represent the Oakland Cannabis Buyers Cooperative, which was a group that sold marijuana in Oakland, California, to people with various ailments. Randy was brought into the case because he was an expert on the Ninth Amendment. And this question is, does the Ninth Amendment protect the right to marijuana? But eventually the case expanded to talk about the Commerce Clause. What happened? You had two women, Angel Raich and Diane Monson. Angel had this sort of a very, very serious illness that made her lose a lot of weight. And the only thing that actually helped her recover her health was actually, is a vaporizer, was actually, some people know what that is, it vaporizes the marijuana and she inhales it through this bag. So she's not actually smoking joints, she's smoking in a sort of, think of vaping before vaping was a thing, right? Look at it, that's what vaporizers used to look like, now like little USB things, right? But she used marijuana to help with her conditions. This is her when she was in better spirits. That's actually a hash pipe if you want to just look a little carefully. It's like Waldo's, like you have to spot in the picture, right? And this is Randy some 20-something years ago, and he represented them. At some point, the feds raided the property of Dan Monson, who had marijuana plants, as did Raich had marijuana. And they seized them. And then the lawyers filed suit against the federal government. Alberto Gonzales was the attorney general. And they argued that Congress cannot regulate the local cultivation of marijuana. Now, let's just think about this for a minute, right? We have Wickard, right? Wickard says that the government can regulate the local growing of wheat. Right? Why? It's economic activity, and we can aggregate economic activities together, and his local growing of wheat has an effect on interstate commerce that's substantial. That's Wickard. Tanner, why was your argument in Raich any different? Not what the court accepted, but just how was the case presented? Why was Raich and Monson in a different position than was Wickard? I'm sorry, Filburn. What's the difference that they argued? You're next, but let's give it a minute.
I know that they are different, but
well, the court ultimately didn't think they were very different, but at least how was the case argued? That's what I'm asking you about. All right. Yeah, go ahead. Natalia, I'm sorry?
They said that Wickard involved commercial farming, which was a quintessential economic activity.
Oh, very
compared
good.
to just for personal home use.
Okay, very good. Thank you so much, Natalia. The distinction that Randy tried to draw was based on Lopez, right? Lopez says Congress can regulate local economic activity, but Congress cannot regulate local non-economic activity. Possessing a gun in the school zone, non-economic. Domestic violence, non-economic. Here, the marijuana was raised in California and was never sold. It was gifted for free, right? It was an act of benevolence, right? Act of charity. All the tools used were local. The seeds were local. The buds were local, I guess, right? Everything was local. The people were laughing. I know why they're laughing, right? Everything is local, right? There's no sale of the marijuana. Okay, Tanner, does the court accept this argument?
Kind of.
No, they don't. No, not even close. David, does the court accept this argument?
No.
No, why not?
Because they were engaged in producing the marijuana, which was in itself economic.
Okay. How does the court define economic?
They use like the Webster's dictionary.
Yeah. This is,
Production, distribution, and consumption of commodities.
yeah, this is Randy's least favorite dictionary in the world. By the way, Scalia hated Webster's third. He loved Webster's second, but he hated Webster's third, made all these changes which he didn't like. He actually has an article where he grouses at Webster's third dictionary because Webster's third says imply and infer mean the same thing, and they do not. But the majority does what Kimberly flagged about 20 minutes ago, right? Justice Stevens writes a majority, and he says, well, what does economic mean? I have an idea. Let's look up in a 1960 dictionary, right? Whatever, who cares, right? And economic, he says, is the production, distribution, and consumption of commodities. And therefore, producing marijuana, cultivating marijuana is economic activity, right? Once you adopt this broad definition of economic, Lopez becomes very hollow, right? Once you say anything that involves production, distribution, and consumption, using stuff, right? Then everything is there. I mean, come on, isn't carrying a gun consuming a gun? Right? Isn't carrying a gun to a school zone consuming it in some? I mean, you don't eat it, right? But you're using it. You're carrying it. So you do a gun, you carry it, right? If this is a definition of economic, then Lopez was wrong. So what gives, right? The composition of the court didn't change from Lopez, right? You have the same members of the court. So what changed from Raich to Lopez? Well, Justices Scalia and Kennedy, who were in the Lopez majority, flipped. They went to the other side, right? And by changing that, you went from a 5-4 decision for the narrow federal power now to a 6-3 decision in favor of the broad federal power. Now, why did Justices Kennedy and Scalia flip? Oh, this is one of the things that drives conservatives nuts. Kennedy apparently had a soft spot for drugs, and that he had some sort of either a death in the family from someone who had addiction. There was some sort of sob story, right? So apparently he just wasn't willing. He's from California also. So maybe he just wasn't willing to have Californians have access to this awful plant, whatever it was, right? Scalia, though, wasn't in that boat. I'm sure he hated hippies using drugs. He's very clear about that. But his opinion was a little bit different, and I want to walk through that. Nolan, walk me through, please, the Scalia majority opinion. I'm sorry, the Scalia concurrence, right? He doesn't exactly agree with the majority, and in some regards says, maybe I don't agree at all. He's sort of like cagey about that, right? He's like, I don't agree, maybe I disagree, and I'll leave you guys to figure it out, right? But what's Scalia's concurrence about there, Nolan?
growing will allow, like local growing will allow weed to get into interstate commerce, because what's to stop them from distributing or selling or moving the weed units?
Yeah.
I think he uses the necessary and proper clause.
Yeah.
To get there.
Yeah. So let me walk through the Scalia opinion, right? Congress has an interest in regulating marijuana nationwide, right? We have, drug agents in every state. We have people at the border checking, boats and shipments for drugs, right? We have international people checking for drugs. We have a very highly regulated system to keep drugs out of our marketplace, right? It's called the Controlled Substance Act, right? The CSA. Scalia says, look, let's be clear here. This is not economic activity. He admits that. He says, look, growing marijuana and not selling it, that's not economic. He says poo to Webster's third, right? That's not the real reason why. But he cites Lopez. And Lopez says Congress can regulate non-economic activity if it's essential to a broader regulatory scheme. If it's essential to a broader regulatory scheme. This is right from Lopez. We mentioned this a few minutes earlier, right? This broad scheme is our nationwide war on drugs. And this is a necessary and proper clause. You can go after local activity if it's essential to enforce a regulatory scheme, right? So even if it's non-economic activity, you can still regulate it. And Congress could conclude that prohibiting local marijuana from the marketplace could be undercut if local marijuana was permissible, right? Because if people can buy local pot, they won't need to buy pot from other states. So Scalia's opinion was premised on the necessary and proper clause. In other words, he says, this is necessary and proper, right? It's a both necessary and proper means for Congress to regulate marijuana nationwide, right? That's Scalia's insight, right? Local activity, even if it's non-economic, can still be regulated to ensure Congress has an effective nationwide scheme. Questions on that? Sergio, you look a little perplexed by it.
Well, it's just because of the timing of it. So in 2005, only a few states legalized marijuana. So is the statement that they could buy marijuana from other states is just kind of weak?
No. It's that people in Utah could buy it from California. In other words, if people in California are allowed to grow it, they might sell it to people in Utah, where it was not legal, right? Therefore, you're introducing a new channel of marijuana that's not regulated in the same way as others is. Yeah, Mitchell.
So by defining this as economic, I find it strange that it's a black market economy where it's not regulated by the government. So how can they claim that they can regulate something that they don't even really allow? I'm trying to put in words.
Yeah, no, I get your question, right? So Scalia says that, or actually, also, this is more the majority, right? The majority says we need to regulate the national market for marijuana, which is illegal, right? How can you have a national market for illegal stuff? It's a fair point. I think it's well stated. But with Scalia's perspective, it's not about whether it's legal or not. Congress has the power to regulate that nationwide, and therefore they can regulate nationwide, they can swoop down and regulate local activity. Everyone with me? Okay. Now, there was an important aspect of the Scalia opinion they want to focus on, right? He focuses on non-economic activity, right? You'll read the Obamacare case for class, I think, on Tuesday. It's Tuesday, right? Tuesday or Thursday, whenever it's Tuesday or Thursday. And the ACA says that the Affordable Care Act says people have to buy health insurance. And why they have to buy health insurance? To ensure that enough people are in the marketplace, right? If we have all this really great health care and people aren't buying insurance, it'll get really expensive, right? All these sick people buy insurance and health people will not buy it. That'll be a disaster. So the ACA says in order to have an effective national health care scheme, individuals have to buy insurance. Does that fit within Scalia's ruling, right? Is a decision not to buy insurance a local activity that can be regulated, right? Whether it's economic or not doesn't matter. If it's a local activity, Congress can make it happen. Because if people don't buy insurance, it'll undercut the national scheme. But, is a decision to buy insurance activity? Or is it inactivity? You see what you do, right? First the court tried to redefine economic, and that didn't work very well. And then the Obamacare case, the court tried to redefine what activity was, and that kind of worked. So in the Obamacare case, the case turns on whether, in fact, the decision to go uninsured is activity or not activity. Because if it's not activity, it won't even fall within Scalia's opinion. Stay tuned for that on Tuesday. Right? But the majority, by a 6-3 vote, upholds the Controlled Substances Act as applied to this locally grown marijuana. I'll do the dissents in a minute. Any questions on the Scalia majority? I'm sorry, I wish it was Scalia majority. The Stevens majority of the Scalia concurrence? Okay. Who's next? Yeah, Nick, give me the O'Connor dissent, please.
Seems to have a problem that it doesn't, they don't answer the question of whether or not it has a substantial effect on interstate commerce.
Would she defer to Congress's judgment here of how to regulate marijuana nationwide?
Yes.
No,
she doesn't. She wants an explanation.
Yeah, O'Connor would not be so deferential, right? She would want evidence showing that Congress actually has this national scheme that requires local regulations, right? She won't just take Congress's word for it. The dissent was joined by Justice O'Connor and Justice Rehnquist, or Chief Justice Rehnquist. I think I've mentioned this before, but Justice O'Connor and Justice Rehnquist actually dated in college. Well, this much was known, but what wasn't known until fairly recently was they dated a lot. They went out like 30 times. And he proposed to her by letter. Can you imagine? He was clerking at the Supreme Court, and he proposed to O'Connor. She said no. Well, you know, she said no. She dumped him, and she married someone else. It worked out well for her. But it wasn't known until recently there's a proposal. They never told anyone. This came out in their papers, right? So Rehnquist proposed, and O'Connor said no. When President Reagan was looking for a woman to be on the Supreme Court, Rehnquist was pushing O'Connor, his former girlfriend, which is, I say whatever you will, but you know, it's kind of cool. Now, the sad part is Rehnquist was first in his class, and O'Connor, I think, was second or third in the class. He got a job clerking at the U.S. Supreme Court. She could not get a job anywhere at the time. Women just weren't hired. They offered to hire her as a legal secretary at the law firms. And she found her way into be a prosecutor and into state government, and she became a state court judge and was the first woman on the Supreme Court. She's now in her 90s, and she's quite ill. It's actually a sad story. She retired from the court in 2005 to take care of her husband, who was suffering from dementia. She stepped down. She was still in her prime. And the sad part was he soon degraded quickly, and he lost all sense of who he was. He forgot who she was. And he actually was moving to a home where he found another girlfriend because he didn't know he was married. It's really tragic. So she actually left the court to take care of him, and then he sort of faded away. Now she too has forms of dementia, so she's not engaged in public life anymore. But she's a remarkable story. A couple good biographies about her. But that's some of the history there. But O'Connor dissented. Rehnquist joined her. At this point, Rehnquist was quite ill. He didn't even go to court anymore, so he couldn't even do work. He died about 4 or 5 months later. So this was his last major cases. The last opinion is from Justice Thomas, who, as you know, thinks everything's unconstitutional. He says we need to go back to first principles, go back to the original meaning. He says that Monson and Raich use marijuana that was never bought or sold, never crossed state lines, and it has no effect in interstate marketplace, right? If Congress can regulate this under the Commerce Clause, then it can regulate anything. And the federal government is no longer one of limited powers. Indeed, after Raich, it looked like the entire Lopez thing was for nothing, right? You had this great decision, Lopez, wow, we have these limits, and never mind, right? Everything's economic. Until the Obamacare case, which would not happen until 2012. So when I was in law school, we had Raich, but we did not have NFIB. So I was like, where's this going? Then NFIB brings together virtually everything. And let me pause here, then I'll wrap up the class. Any questions on Raich? Okay. Your next class focuses on the Obamacare case. So I want you to read, it's a long excerpt, I know, of the case, but I want you to read the entire thing. I also gave you a brief excerpt from one of my books, which I'm giving you for free. You're welcome. I could charge you. I don't want to charge you. It's don't tell the publisher. They don't care. I don't think they care. But the goal for next class is to walk you through the history of the Obamacare case. This case brings together everything we've talked about so far. It involves enumerated powers, Commerce Clause, necessary and proper clause, spending power, federalism, the role of the courts. It's like everything comes together in a perfect storm for ConLaw. And it's a perfect way to wrap up the topic on enumerated powers. And that'll be the last topic in this area. Okay. Questions? I will see you all on Tuesday. Thank you so much.